Hey everybody, this is Deb with Truthification Chronicles, and some of this is going to make you really mad, and some of it will make you really happy, so it's one of those things where, just hang with me, okay, till the end. All right, this is a lawsuit that has been put on the United States by Peter Strzok. Now, y'all know who Peter Strzok is, right? The FBI agent who was texting Lisa Page back and forth and everything. All right, well, here's the situation, folks. He thinks he's been wronged, that he was wrongfully dismissed, and that he has reasons to sue the Attorney General, the United States Department of Justice, FBI Director Christopher Wray, and the Federal Bureau of Investigation. Those are the defendants. So let's see what Pete has to say here. Peter Strzok served his country with distinction in the armed services and as a special agent with the Federal Bureau of Investigation for more than 25 years. In June 2018, the FBI proposed to fire Special Agent Strzok primarily due to text messages he had written in which he expressed his political opinions regarding the 2016 presidential election and then candidate, now President, Donald Trump. The proposal to discharge Strzok identified the Assistant Director of the Federal Bureau of Investigation Office of Professional Responsibility, and you will see that called OPR. Candice Will, who had been tasked with issuing disciplinary reactions relating to senior officials for the FBI for more than a decade as the deciding official. The proposal also confirmed that Strzok could then appeal any disciplinary decision to the FBI's Disciplinary Review Board, all in accordance with the agency's standard procedures. But here's what happened, and I'm going to really kind of go through this a little faster. Director Will issued a decision, and she rejected the proposal to fire Agent Strzok, and instead said that he should be demoted and suspended for 60 days without pay. Okay, that was the basic gist of it. Now, the interesting thing is, this is actually the document that confirms that, but the weird thing is, and I know it's not a really good copy of it, but this is the best I have. And it goes through and it lists all the reasons why this guy should totally be fired and all the things he violated and everything. And then at the end, it gives this summary and says, yeah, but this only is worth like a week suspension, and this is only 5 days suspension. And so all in all, he should only be suspended for 60 days. But let me show you just a few things in here. Now, this is 27 pages long, so obviously I'm not going to read it, but oh boy, it is a read. I went through the whole thing. And essentially, it goes through and it talks about all the things he did wrong, which are myriad, and things that he should have been doing and he didn't. Now, I'm going to have to go through, let's see, unprofessional conduct, and then it has text messages here, and some of these I don't recall seeing before. I mean, a lot of them are the ones that we've seen, but some of them aren't. And it just really, I just can't believe this guy could then turn around and say that he wasn't biased. I think that maybe in this lawsuit, we need to put the people on the jury that say these kinds of things about Peter Strzok and see if he thinks that jury is unbiased. So anyway, he just went through, it gives a lot of them. Look at this, all these different ones. And like I said, some of these I just don't think I remember seeing before. But yeah, there were tons of them. See, there were so many. And this lady went through and she listed all of these things. This is what you did wrong. You did this, and you've got this, and you've got this. So this was a huge part of it right here, because see, look, they just keep going on. I'm on page 11 here, folks, and it's almost all of these. It just continues on, keeps going. But a big part of it was the public reaction to the text messages that, it really gave the FBI a black eye. And they were very upset about that. Plus, they were using the FBI devices, which they weren't supposed to be doing. So, and in this, if you read this, I'm going to leave all the links down below. This GA here, I think that stands for General Attorney. Whatever it is, it's the abbreviation they use for Lisa Page. Because this was about him, it was not about other people. I mean, it was specifically him. So they use abbreviations. They have like D for director, and that would be Comey. And then DD, I think, is McCabe because he was the deputy director. So they do mention those. But anyway, it goes on. I mean, security violations because he used his personal email account to conduct FBI business. And the worst thing is, the guy admitted doing this. Okay? He actually admitted to doing all of these things. And then he turns around and has the audacity to sue because he thinks he was wrongfully terminated. It's crazy. Yeah, see, like here, D and GA, that would be Comey and Lisa Page, were also found to have used their personal email accounts to conduct FBI business, which is interesting as well, right? The situation is replete with irony given the FBI's criticism of Clinton for having done so. I mean, definitely, they were pointing that out, so it has been pointed out. And now, here's where it gets really interesting. You admitted your wife gained access to your personal cell phone and email accounts in 2017. You noted her access was unusual and limited to a specific period of time and claimed she did not view any FBI case-related information. You claimed you did not have any work-related communications on your personal email account because you had double deleted all such communications. You declined the OIG's request to review your personal email account. Evidence was also uncovered of your and Lisa Page's use of iMessage on your personal cell phones to conduct FBI business. So, they were going around, and it's very interesting. And here's about, they had text messages back and forth. Get this. I mean, this is kind of tricky here. He said, "My wife has my phone, read an angry note I wrote, but I didn't send you. That is her calling from my phone. She says she wants to talk to you. Said we were close friends, nothing more." And then Lisa Page says, "Your wife left me a voice message. Am I supposed to respond? She thinks we're having an affair. Should I call and correct her understanding? Leave this to you to address?" And he says, "I don't know. I said we were close friends and nothing more. She knows I sent you flowers. I said you were having a tough week." Yeah, because guys often send their coworkers who are married to someone else flowers. Oh, anyway, so, yeah, and here's where, during a text exchange from April 4th to 8th, 2017, you and Lisa Page discussed that your wife had access to your devices and had located Lisa Page's husband's full name, found a hotel reservation ostensibly used by you and Lisa Page during a romantic encounter, had access to photographs from your phone, threatened to send all the information to Lisa Page's husband, and also threatened to hire a private investigator. Lisa Page told you to determine whether your wife might use recovery software to locate other evidence of your affair on your devices. And so, yeah, this is serious stuff here. And what was going on, I don't know. But anyway, then it gets into the whole Wiener laptop thing. And the thing is, he had the Wiener laptop. It got in there. Let's see. The case agent immediately reported his discovery up his chain of command. And on September 28th of 2016, Deputy Director, which I think is McCabe, was notified of the discovery of possible Clinton emails. That same date, McCabe discussed the matter with you, and you, in turn, discussed the matter with Lisa Page via text messaging on your FBI-issued cell phones. So this was back September 28th. That laptop sat there without being touched until like the end of October, shortly before the election. I mean, just like a week or so before the election. Yeah, that's what happened. And so this was like a dereliction of duty, that this guy was not doing what he was supposed to be doing, because it was his job to take care of this laptop and to make sure, I mean, he had people who were supposed to be taking care of it, but he was like the overseer, the supervisor of them. And he just left it languish for about 3 weeks and didn't even bother to check to see if they were actually doing anything. Well, the problem was they couldn't do anything with the laptop because they needed a warrant specifically to look at those emails. You see, there was a warrant on the laptop, but that warrant was limited to the stuff about Anthony Weiner sexting that underage girl. And so that's all they could really look at. But in the process of looking for that, that's when they discovered the other stuff. So they would need another warrant to be able to look into what was in those emails. Okay, I know it sounds confusing, but that's the way it works. So they had to have a warrant specifically for looking into those emails. And he just didn't get it. I mean, he didn't bother getting that warrant, even though they had everything they needed. They had probable cause, so there was no reason why they couldn't have gotten a warrant for it. But oh no, he didn't get it because he thought, we can just wait on this until maybe January or so. Yeah, this was before the 2016 election. So this was really one of those things that I don't see how it could not be bias. That he thought it was more important to be working on the Trump investigation. That's where his energies had to go, because it was very important for him to get that taken care of, because that was national security after all. Whereas Clinton's email, it's no big deal. It's not big. And so, this was the thing. They already knew. September 29th, the New York office participants informed FBI headquarters personnel that Weiner's laptop contained hundreds of thousands of emails potentially relevant to the Clinton email investigation. And by this time, I think they already knew that there were classified documents that she had sent. But, no reasonable prosecutor would prosecute. Well, not if he didn't want to be Arkancided, I guess. But anyway, so all of this, they knew about it and was limited to evidence of possible child exploitation by Weiner. But, oh no, we don't need to look into any of that. And you stated that you believe there was something there that potentially Clinton email investigators were going to have to pursue, and we're likely looking at a renewed investigation that will last well into 2017. You said you believed the New York office was processing the data, and that based on your familiarity with similar matters of data processing, it would not have surprised you to have heard back from the New York office in early November or early December. So see, he was not in any hurry whatsoever. You also emphasized that your focus in late September 2016 was on the Russia investigation, which you deemed to be more critical and time sensitive. Yeah, but there was no bias. See, this is just what it boggles my mind, folks, that they could just say there's no evidence of bias. That's hooey, just hooey. And, that the discovery of additional emails on Weiner's laptop was not a ticking terrorist bomb, but Trump was, even though everything about the Trump investigation was so totally bogus. So that's what I said. You're going to be really ticked when you read through this, because even after she lays down all of this stuff, then she turns around and says, 60-day suspension. 60-day suspension. And by the way, that's 60 calendar days, not 60 work days. All right? So, yeah, that's something. So this is something that you can go through and read. I will leave the link down below if you're inclined to do so, but it will just, I was reading through this, and honestly, I didn't really know what it was. This was the first document I read, and I thought, oh man, she's nailing him. She's putting down absolutely everything. And down here at the bottom of it, like I said, it's 27 pages long, but down here, let me get to it. And she went through and she says, I've considered all mitigating factors supported by the record, including but not limited to your 21 years of FBI service, outstanding performance record, and numerous awards, including those noted in your written response. I am also cognizant of the fact that you were assigned to 2 very stressful and high-profile investigations during the time of your misconduct. Nevertheless, severe aggravation is warranted because your inappropriate text messages were extensively covered by the media and brought extreme criticism on the FBI and DOJ. Your conduct also caused immeasurable harm to the Bureau's reputation with DOJ, other government officials, and the American public. Potential harm to the Bureau's reputation is listed as an aggravating factor for all misconduct in the penalty guidelines. Your inappropriate political comments on your FBI-issued cell phone resulted in skepticism about major investigative conclusions in an extremely high-profile case and required you to be removed for just cause from the special counsel's investigation. Your actions showed extremely poor judgment. In addition, your use of your personal devices and personal email account to conduct FBI business paralleled the very nature of the case you were tasked to investigate. Ironically, you characterized Clinton's use of a private email server to conduct government business as, quote, ill-advised, really dumb, and borderline criminal. The level of hypocrisy seen in your conduct is staggering and further calls into question your judgment. Your impermissible use of your private email to conduct official FBI business in a matter that solved a possible misuse of a private server and email accounts to conduct government business created a strong likelihood that the public image of the FBI would be significantly tarnished and the investigative conclusions of one of the FBI's largest cases would be called into question. And so it's like, yeah, hello, do you see what you did? And again, finally, following the discovery of potential significant new evidence in the Clinton email matter, your lack of proper oversight and diligent follow-through as a supervisor created an enormous embarrassment to the Bureau and has been cited by some as having altered the results of a presidential election. So she took him to task, but then, in sum, I am suspending you from duty without pay for 60 calendar days. Ooh, whoopee ding dong. I got to that part, and it was like, after all of that stuff, then, well, I'm suspending you for 60 days. That's it? That's all? Then someone else stepped in, and he actually got fired. But let's go back to this, because he goes through and he says, okay, so on August 9th, they fired him, and this was this assistant director, Will, who decided, yep, going to do that. Now, they had given him this thing right here with this last chance adjudication agreement. And so that was what they gave, saying, yeah, he agrees to complete a suspension of 60 calendar days. And, that was the agreement. Well, like I said, this assistant director, Will, turned around and said, nah, this guy deserves to be fired. And so he got fired. And that's what Strzok is really upset about. The concerted public campaign to disparage and ultimately fire Special Agent Strzok was enabled by the defendant's deliberate and unlawful disclosure to the media of texts intended to be private from an FBI system of records in violation of this Privacy Act. So he thinks his privacy was violated as well because of this, and his freedom of speech, because of his protected political speech in violation of his rights under the First Amendment of the Constitution, that he was fired. And I mean, it just is kind of funny when it goes through this, and of course, he is the plaintiff, and then the defendants are the DOJ and the FBI, essentially. And it goes through and it gives these facts. Well, there's another one. Let me see if I can find it here. I don't know. There's another one that's here. The defendant's statements of fact. So that was an interesting one to see compared to his facts here that he has. But essentially what the deal is, he has 3 counts that he believes that he's been wrongfully terminated in. And I'm sorry for scrolling. It's just I can't remember exactly where it is. They're trying to blame Trump, of course, for, discrimination against him and for different things. And they bring in Kellyanne Conway because they're talking about the Hatch Act here. And it's like, yeah, well, she got away with, violating the Hatch Act, but we can't. And it's like, no, not the same thing. Not the same thing at all. Kellyanne Conway was not in charge of any investigations against the people. The Trump administration has consistently tolerated and even encouraged partisan political speech by federal employees, as long as the speech praises President Trump and attacks his political adversaries. Oh, I mean, really, this is what they did right here. They're talking about Conway and everything. So I told you, they just go through and do that. And then they go through and give some of the tweets that Trump put down. I don't know where are they? Oh, well, here are some of the text messages. So they do at least admit to those. And, not near as many as there were on the other one. So, I mean, the funny thing is, he does admit to it, to doing all these things. But then he turns around and he says, well, but you can't blame me for doing these. It's like, what? No, wait a minute. You admitted you did something wrong. And then you turn around and you didn't care. I mean, this details it all here, folks. So let me go on down here. Let me just find it. Oh, at this point, they have all of Trump's tweets here about Strzok. Oh, yeah. Page 17. Yep, that's interesting. So those were all of those. And so essentially what they're saying, there are 3 counts. There was a violation of Strzok's Fifth Amendment due process rights, that the defendants refused to abide by the final decision to suspend and demote rather than fire Peter Strzok. And that, that wasn't fair. And then they have a violation of the Privacy Act because they let out the different text messages without his permission, of course. And then the other one was the Hatch Act one, I think, right? His freedom of speech. It's his First Amendment. I think I already did that. Oh, yeah, here are the counts. So this just summarizes them. Unlawful termination of plaintiff's employment because of his protected speech in violation of the First Amendment to the United States Constitution. Count 2 is infringement of plaintiff's right to due process under the law in violation of the Fifth Amendment to the United States Constitution. And violations of the Privacy Act, and there's the code for that. So those are the 3 counts that he's complaining about. And then here's a document that is Peter Winn, who is the director of the Office of Privacy and Civil Liberties at the United States Department of Justice. And he is the one that when they said, can we fire this guy? He said, yeah. So this is his declaration that says, here's why you can fire him. And so that was what that one was about. And then this is a memorandum in support of the defendant's motion to dismiss. Because here's the deal. I mean, this one goes through, this is 53 pages. Man, you have to love to read if you're going to be involved in the legal system, I think. But what they do is they go through and they say, plaintiff's interest in speaking was outweighed by the FBI's interest in ensuring continued integrity of its mission. The Bureau's compelling interest in objectivity and in avoiding appearance of political bias cannot be overstated. The Pickering balance weighs in defendant's favor because of plaintiff's role and the work-related content of his speech. And plaintiff's speech was directly related to his role in the Clinton email and Russian interference investigations because he was in charge of the investigations, and his opinion about those two people involved made a huge difference. Plaintiff occupied a high-level policy-making position. Plaintiff's position fell within a policy area. Plaintiff's position was at a policy level. The FBI's interests were implicated by plaintiff's speech. So in other words, he wasn't just like a rank and file type FBI agent. He was like really highly placed. And because of that, he had to be more careful about his words, and he wasn't. I mean, he really did some dumb stuff. So you know what they say, these people are stupid. And he really was on this. And plaintiff's due process claim is meritless. Plaintiff had no property interest in his former job. Plaintiff cannot plausibly claim that he was denied due process because, he went through the different stages. They did. And then plaintiff cannot succeed on his Privacy Act claim. Plaintiff does not allege a Privacy Act violation with respect to any disclosure by officials in the White House. Defendants are entitled to summary judgment as to the department's disclosure of plaintiff's texts to members of the press. So they are saying essentially the department's disclosure of the text messages from OIG investigation reports was compatible with the purposes for which those records were collected. And the department disclosed the text messages pursuant to a routine use exception published in the Federal Register. And plaintiff cannot establish that the department's disclosure to the news media was a willful or intentional violation of the Privacy Act. So essentially, he doesn't have a leg to stand on. And that's where they're standing. And notice this. This was filed the 18th. So it just came out. And I will leave it down below. If you want to read the whole thing, I usually like to look at the table of contents, which is what this is, and then go all the way down to the bottom and see what the conclusion is. So essentially, given the department's thoughtful treatment of its disclosure and specifically with respect to any potential Privacy Act implications, plaintiff cannot prove willfulness or intent because no reasonable finder of fact could conclude that the department disclosed the text messages without grounds for believing its action were lawful, let alone that the department flagrantly disregarded any rights guaranteed under the Privacy Act. So, therefore, plaintiff is not entitled to damages because he cannot prove that any disclosure was, quote, intentional or willful. For the above stated reasons, the court should dismiss count 1 and count 2 of plaintiff's complaint, or, in the alternative, enter judgment in favor of defendants as to those claims. Further, the court should enter summary judgment in defendant's favor as to count 3. So, that's what they're talking about right there. And that's where we're at this point. Oh, just very interesting. So, anyway, that's the situation with Peter Strzok right now. And there are more documents out there. Those are just the ones that I chose because I will leave a link to this down below, the court listener, and you can actually go through the entire, if you're really inclined, here's the whole case. You can start up here at the top and find out when it was filed and everything. And some of them you can download and some of them you have to buy on Pacer if you're going to. But, you can go on here and you can download them and it doesn't cost anything for those. And so, yeah, there's motion for miscellaneous relief. There were a couple of motions that were put in by Strzok and his people, I think, and they were rejected. And this is interesting, a sealed document. I don't know what the sealed document is, but yeah, only available to authorized persons. Why would it be sealed? I don't know. So yeah, any of these that are blue here that say download PDF, you can do that. And it will bring them up and you can just download them from there. And so here are there's a lot of them. There's a lot of actions that have been going back and forth. But here's essentially the different ones that I showed you, some of these. And so, yeah. A lot of stuff happening. Notice of appearance. Ooh, I didn't see that one. Sorry. Let's look. The undersigned attorney, Grace Sue of the United States Department, enters her appearance in the above captioning. Oh, so they're adding somebody new. Trial attorney. Okay. Oh, and the judge in this is, let me find it here. The judge in this, and I'm not sure if it says up here or not. Does it say? No. What's her name? She's an Obama judge. Oh, here it is. Judge Amy Berman Jackson. Yeah. She is definitely that. But then it says case assigned, reassigned. So maybe they I don't know if they reassigned it. I don't know. Yeah. So you can go through all this and you can see if you want to again. But those are the highlights, at least what I could find. And, lots of documents. Oh my goodness. No wonder lawyers get paid so much. They got a lot to do. Oy. Yeah. So, a lot of things going on, but it looks like Peter Strzok is probably not going to win his case. I hope he doesn't. Because once you read through that one exhibit, it calls it Exhibit 4, but on here, if you're downloading it, I think it's the 5th one that it has. But anyway, the whole thing about it is it lays down everything this guy did wrong. And it says you admitted to it. And so he admitted to doing these things. He violated all of this stuff. There's no way in the world this man should still be an FBI agent. But he wants to be, and he thinks he deserves it. So, I'm wondering, after we get the IG report on the FISA abuse, is this guy even going to be able to say anything? Because surely he was in on that. He knows the stuff that they put out there was fake. And I'm pretty sure he was part of the whole thing starting against Trump, and it was all illegal. Was he part of the other FISAs? The one on Mike Flynn and George Papadopoulos and Manafort. All of those were out there too. And was Peter Strzok part of that? So it's going to be interesting to see. I heard on Rush Limbaugh today, he was talking about this, the news that came out that there was some document that was altered. Well, this happened with Mike Flynn. I mean, we've been seeing that for a while, that they altered this 302 in order to make it look like he was guilty. Well, when Rush was talking, he was focusing in on this Carter Page one. I think that the reason this report is going to be so large is because it's not going to be just about Carter Page. I think the big bombshell we're going to see is that it's going to tell about the other FISA warrants that were out there on other people. And so when you take that there were others out there, and then you take that they were illegally started as well, you've got a big bombshell. So we'll see what happens when all of that comes out. Going to be exciting time. I think between now and Christmas, it's going to be who knows what. I'm kind of like every day it's, okay, what's going to happen today? So lots of things happening, definitely. And I heard rumors. This is rumors, but it was on Twitter, and it was by a fairly reputable person on Twitter, that Devin Nunes has found a loophole that allows the minority to do investigation too, and that they will be able to subpoena people. Okay, that's all I know. All right, that's all I've seen so far on it. Anyway, so that's what I've got for you on this one. I want to thank you for stopping by, and I'll see y'all later.